Today we're going to talk about the sale of real property. Just to orient you for where we are in the class, we began by talking about what property is, right? What rights are included in that bundle of sticks that we call property. We focused on the right to use, the right to exclude, the right to possess, all as part of what we talk about as owning property. Then we talked about how people acquire property. We talked about first possession, how someone becomes the first owner of something that was res nullis, the unowned thing. And then we talked a little bit about subsequent possession, the way that property is transferred, but between owners, but we bracketed sale of real property, which is of course the way most people acquire most of their property. And that's what we're going to talk about now. Then we talked about the different kinds of estates in land, or how you can divide property up, either over time between present interests and future interests, or within a single time period in terms of concurrent estates. Then we talked about landlord-tenant law, about how one can carve a sub-estate out of the full fee simple and transfer that sub-estate to a leaseholder for a period of time, and the various conditions and requirements that accompany that conveyance and the contract of the lease. And now today we're going to talk about the sale of real property. So let's start with a hypothetical. Wendy and Henry Baker, a married couple, find their dream home, a 3-bedroom, because it's New York City, it's a co-op, but it could be a 3-bedroom house somewhere, that the owner, Adam Stone, wants to sell. They verbally agree on a sale price of $300,000. So stopping there, is this an enforceable deal? Right? They have an agreement between the willing parties and a price. Now, if the parties want to go through with it, this is perfectly fine, right? The law doesn't get involved. The law only gets involved if one or the other party decides that they want out of this agreement that they've made. And at that point, the question is this a deal that can be enforced against the party that wants to leave? And the answer here is probably no, because an oral agreement must be reduced to a writing for it to be for it to create a valid obligation to transfer land. I just want to throw out there, we're going to talk about it in a minute, but think about, as you read this or listen to this, what other terms might they want to agree on besides the sale price? Because there are a lot of them. Remember our old friend, the statute of frauds? Right, this is the New York statute of frauds. Any estate or interest in real property other than a lease for a term not exceeding 1 year, we looked at this in the context of the landlord-tenant relationship, cannot be created, granted, assigned, surrendered, or declared unless by act or operation of law, we talked about that as adverse possession mostly, right? Or by a deed or conveyance in writing, subscribed by the person creating, granting, assigning, surrendering, or declaring the same. So why do we have a statute of frauds? Just a reminder, right? Obviously, it's called the statute of frauds, and the goal is to prevent fraud, among other things. It also prevents perjury, right? If by requiring a writing, we make it much less likely that people are going to come into court, get up on the stand, and lie about what they said to each other or what their agreement is. Written agreements are more certain than oral agreements. Again, people can enter into an oral agreement and follow through with it, and that is perfectly fine. The statute of frauds only comes into play when the parties either disagree about what their deal is or one of them wants to get out of it. A written agreement is much clearer, much less likely to have a disagreement, though certainly you can have plenty of disagreements with a written agreement as well. But written agreements are less open to misinterpretation or miscommunication because the words are written down. And the fact of a writing also helps the parties understand what they are undertaking and realizing that they are in fact making a commitment. Let's go back to that hypo we started with, where the Bakers want to buy Stone's 3-bedroom house and they agree on a sale price of $300,000. If the Bakers had given Stone a check for a down payment, Does that make it an enforceable deal for the sale of the house? Right, this gets to, a check can be a writing, but this gets to the point in the statute of frauds about who has to sign the writing, right? And in this case, the baker's check can't be a writing sufficient to satisfy the statute of frauds because they are the purchasers. They are the ones who want to acquire an interest in land. They are not the ones who are creating, granting, assigning, surrendering, or declaring their interest in land. It is not their signature that is critical for the statute of frauds. It is Stone's. And that brings us to the case of Hickey versus Green, because of course this was exactly the issue in this case. Right? So what's going on here? Right? We have the Hickeys want to buy Green's house. They agree on a price. They have an oral agreement, and the Hickeys provide Green with a down payment check. That down payment check does not have a payee specified. And I just want to stop here for a second and point out that this is a really bad idea. Do not give someone a signed check with a blank payee line. Now here they did it because they weren't sure whether Green should be put in or Green's son, but don't ever do that, because if you give somebody a signed check with a blank payee, they can put in whatever they want. Especially don't do this in the context of sale of or purchase of property, right? There you want whatever the down payment is to be held in escrow. But that's a side point. So here we have Hickey and Green. They've agreed on a price, and Hickey has made a down payment. Hickey then turns around and they sell their house, right? They list it, they find a buyer, the buyer gives them a down payment, and unlike Green, who held on to the check, the Hickeys endorse the back of the check and deposit it. Green then changes her mind. She gets a better offer and says, you know what, I'm going to go with the better offer. Hickeys, you lose. So the Hickeys come to court trying to enforce their oral agreement. Now, interestingly here, the Greens and the Hickeys, right, proceed on stipulated facts. There is no dispute about whether there was an oral contract and whether or not the Hickeys gave Green a check. So why doesn't the court just say, you made a deal, stick with it? Right? There's no risk of fraud here because both parties agree what their oral contract was. The problem is that there's no exception in the statute of frauds for when the parties agree there was an oral agreement. Right? It's fine as long as the parties agree that there was an oral agreement and want to keep it. Right? And that, if they want to fulfill their oral agreement, then the statute of frauds doesn't come into play. But here, Green wanted to get out of the deal. And she's saying, there's no writing. Statute of frauds says you cannot create or transfer an interest in land without a writing, so I don't have to do this. Right? Now, interestingly, right, the Hickeys, who deposited their check, right, are obliged to sell their house, right? Where Green, who didn't deposit the check, is not obliged to the Hickeys under the statute of frauds. Why? Because of the lack of a signature by Green on the check from the Hickeys, right? She has not endorsed it, right? Her signature is the one that matters. The Hickeys, on the other hand, endorsed and deposited their check. Thus, there's a writing for their sale signed by the party to be bound. Right? So it's much easier to hold Hickey to the agreement to sell their house than it is to hold Green to their agreement with the Hickeys. So the only writing in the Greens versus Hickeys dispute is a writing that is signed by the Hickeys. And again, they are not the ones who are conveying an interest in property. They're the ones who want to acquire it. So why is Green bound anyway, right? Pretty good argument in law. We need a writing. We don't have one. The answer is equitable estoppel, and maybe part performance. We'll talk about that in a second. I just want to throw out here, what if Green had denied the agreement rather than proceeding on stipulated facts? Do we get a different result? I think maybe or probably, right? That's why there needs to be a writing. So now we take our hypo and turn it into something similar to what actually happened in Hickey versus Green. The Hickeys had relied on their oral agreement with Green and sold their house. Right? They had materially changed their position in reliance on that agreement. In this hypothetical, it's a little bit different. With Stone's consent, the Bakers immediately begin repainting the inside of the house and they replace the kitchen appliances. So they start to improve the property before the transfer at the closing, but after they have an agreement. 1 week later, though, Curtis shows up, offers a higher price for the house, and Stone accepts. Stone then turns around to the Bakers and says, well, there's no writing, so I'm not bound by my deal with you. Now, if the Bakers sue to enforce their agreement with Stone, will they win? This is, as you can see, pretty parallel to Hickey versus Green with a couple of extra facts. So the doctrine of equitable estoppel or part performance may be involved here. What would be part performance of the deal? Payments, right? Payments of monies can be part performance depending on the circumstances. Taking possession of the property, making improvements to the property, right? Those are the kinds of things that can be viewed by a court in equity as part performance of the deal that would oblige Stone to go through with this oral agreement, even though it doesn't comply with the statute of frauds. We're going to have some factual questions here, right? Are these improvements sufficient to amount to part performance? Are they really substantial? Changing appliances, repainting the kitchen? Maybe, maybe not. Did they take possession? It's not super clear from these facts, right? That's a question that would have to be answered. What about equitable estoppel? That is about detrimental reliance on the oral promise. Right? That was the Hickey's main argument, that they had sold their house in reliance on Green's promise. They had been induced to substantially change their position in reliance on an oral agreement and would in fact incur serious injury if specific performance were refused. Here, I think in this hypothetical, it's a little, these facts are nowhere near as clear as selling your house, but it would be a question. Maybe I should have shown you this a little bit earlier, but this is also part of the New York Statute of Frauds, right? Section 5-703, subsection 4, which says nothing contained in this section, meaning the part of the Statute of Frauds we were reading before, abridges the power of courts of equity to compel the specific performance of agreements in cases of part performance. All right, so what happens when people do it right? When they enter into a written contract for the purchase of property. This slide has some of the key provisions of a typical contract of sale. They're not all required to satisfy the statute of frauds, but they're very common. Right, just a reminder, for a contract to be enforceable under the statute of frauds, there must be a writing. It can be formal or informal. It has to be signed by the party to be bound, meaning the person who's going to convey the interest in real property. And it must name the parties to the contract with sufficient definitiveness to identify who they are. And must describe the land or the other property to which the contract relates, and must set forth the terms and conditions of the contract in some degree of specificity. So here, the typical kinds of things are the purchase price, specifying usually, right, how much of it is going to be cash, any planned financing, its costs, and we're going to look at that provision in a minute. A legal description of the property, we'll also look at that. The type of title to be furnished by the seller and any warranties of title. We will talk about that next class. The date at which this transfer will occur, and then other details like how they're going to prorate the property taxes, who bears the risk of fire between the contract of sale being signed and the closing or transfer of the real property, an itemization of any chattel or fixtures included in the sale, the terms of an escrow agreement, and then the provision for what happens to the down payment or earnest money if the sale is not completed, and then the signature of the parties. So we're going to look at those provisions in a minute. Okay, so let's start with the specification of who the parties are. This sales contract is offered on blank, fill in the date of the offer, between blank buyer and blank seller. And then you can see this particular provision from the New York Form Residential Contract of Sale, which was created by the New York City Bar Association, also has right underneath the identification of the seller and the buyer, the identification of the broker. And we don't need to worry about that right now. We'll talk about that next class. I do want to point out, though, that this form does not include disclosure of the seller's marital status in the identification of the seller. And as you know from our discussion about owning property as tenants by the entirety, and the inability of one part of a married couple who owns property as tenants by the entirety to convey it without the participation of the other party, that's a fact that the buyer is going to want to know. Then there's a description of the property. You can see that there are up to 3 different ways in this form to describe the property. If the property has a name, Blackacre, right, that can be written there. The street address should also be included, and then the tax map designation. So that's the also a legal description of the property, so that there's no ambiguity about what is the subject of this agreement. Remember, I said that the contract of sale typically has an agreement about fixtures. Fixtures are chattel that is physically attached to the real property. So light fixtures, appliances. And you can see here's the New York form provision. And the default is that the sale includes all fixtures and personal property attached or pertinent to the premises, unless specifically excluded. And then at the bottom, there's a list of things that can be excluded. And there's a list of examples, right? These things include, but are not limited to, plumbing, heating, lighting, cooking fixtures, chandeliers, bathroom and kitchen cabinets, etc., mirrors, switch plates, door hardware, Venetian blinds, etc., etc. And an invitation to strike out anything that isn't relevant, and then an opportunity to specifically exclude fixtures. So if you have the chandelier that your grandmother gave you hanging in your living room and you intend to take it with you when you move out of the house, you're going to want to put that here, that chandelier is excluded from this provision about the transfer of the fixtures. Now, I also want to point out that this warrants, right, that this provision, the seller warrants that they will be the owner of all of these fixtures at closing. So if you bought the window treatments on, a pay by over time plan, the seller here is promising that at closing they will have paid that off and that they will own those window treatments free and clear and be able to transfer them to the buyer. I just wanted to show you that there are other ways to do this. This is from Virginia Form Contract of Sale, and you can see for each of the fixtures that were in that big list in the New York contract, there's a yes/no checkbox to indicate whether it is going with the property. Things like a built-in microwave, a ceiling fan, a clothes dryer, I'm just picking a few randomly here, a dishwasher, a hot tub. That would be nice, huh? Refrigerator, window treatments, etc. Other common provisions in the contract of sale are contingencies. Contingency is a clause that the buyers include when making an offer on a home that allows them to back out of buying the house and get their deposit back if the terms of the clause aren't met. Without a contingency in place, the buyers risk losing their deposit or earnest money if they decide not to purchase the home after making an offer. So an all-cash buyer obviously doesn't need to include a mortgage contingency, but we're going to focus on mortgage contingencies because they are particularly important to most buyers. But I also want to point out the appraisal contingency. So why might you want to include an appraisal contingency? And that is a contingency that the home appraises for the sale price or above that. And typically a bank will only lend up to 80% of the appraised value in a typical primary mortgage. FHA loans are different. We'll talk about that in a class or two. But because the bank in an ordinary conventional mortgage will only lend 80% of the appraised value, if the appraisal comes back below the agreed upon purchase price, the bank won't lend the full amount that the buyer may have been counting on. And the parties at that point either have to end the deal, renegotiate the price, or the buyer has to come up with additional cash. So that may be an important contingency for a buyer that they would want to include. In what are called hot markets, sellers markets, that is often a contingency that buyers waive or do not include because otherwise they're not in competition for a property. So this is a very typical mortgage contingency. You can see this contract is contingent upon buyer obtaining an unconditional written mortgage commitment on or before a specified date for a type of loan, a 30-year fixed loan, a 5/1 ARM, or whatever it is. And we'll talk about types of loans when we talk about mortgages. And an amount that the loan is for, right? And an interest rate that the mortgage will be for, and the length of the loan, right? Not less than blank years, so 30-year, 20-year, whatever the lender wants, the buyer wants, and any points that will be associated with the mortgage. Again, we will talk about what points are when we talk about mortgages. For now, I just want you to see that by including this clause and by specifying all of these things, a buyer can protect themselves from being forced to go through with a deal if, say, interest rates shoot up, or they don't qualify for the loan they thought they could qualify for, and all they can qualify for is a much higher interest rate loan or a shorter length of loan. So by filling all of this out and by including it as a mortgage contingency, the buyer can protect themselves from being forced to go through with a deal if the financing doesn't work out the way they think it will. Okay, and that ends the first of our 3 videos on selling real property. Next up, marketable title.